May 3, 2026. Ashford County Superior Court, North Carolina. 82-year-old Reba Moon arrived in a wheelchair, her white hair pinned back with the same tortoiseshell clip she had worn to church every Sunday for 40 years. She wore a pale blue cardigan. Her hands, folded in her lap, were the hands of someone who had spent a lifetime working, knuckled, veined, steady. She looked at the courtroom the way she looked at most rooms, as a space she had already assessed and determined she could manage. She did not look like a murderer. This was not an accident. The gallery murmured when she was wheeled to the defense table. The murmur was the sound of people revising something they had prepared themselves to feel. Several reporters who had covered enough trials to maintain their objectivity through most things found that objectivity required slightly more effort when the defendant was 82 and moved through the room in a wheelchair and folded her hands in her lap with the composure of a woman waiting for Sunday services to begin. She had told reporters on the courthouse steps 3 days before the formal proceedings began, while a deputy held an umbrella over her head in the light spring rain, that she had done what she had to do. She had said it quietly, without drama, in the voice of a woman stating a simple fact. When the reporter closest to her had followed up, asking whether she regretted anything, she had looked at the camera with her steady gray eyes and said, "I'd do it again." The gallery had replayed this clip for days. It had generated the specific divided response that such statements generate. Some people heard the defiance of a frightened woman who had taken the only action available to her and was not apologizing for surviving. Some people heard something else. Prosecutor Diana Reeves had listened to the clip 4 times in her office the evening it aired, watching Reba Moon's expression, and what she had heard was neither fear nor defiance. What she had heard was certainty, the specific, settled certainty of a person who has done a calculation and is satisfied with the result. The dead man was Reba Moon's grandson, Kyle Moon, 34 years old, found in the farmhouse kitchen on a Tuesday morning in January, unresponsive, by a neighbor who had stopped by to return a borrowed tool. The farmhouse sat on 43 acres of Moon family land in Ashford County, land that had been in the family since 1947, and that was, by the time of Kyle Moon's death, worth considerably more than the family had ever paid attention to, because the county had grown up around it, and the land's value had grown with the county, and no one had fully reckoned with the number until Kyle Moon had begun reckoning with it. Kyle Moon had been, by all accounts, a complicated young man. He had struggled with employment in his mid-20s, had spent a period living with Reba at the farmhouse, and had then stabilized in his early 30s, finding work as a contractor and building a modest, decent life. He had continued to have a complicated relationship with his grandmother, complicated in the way that relationships between people who are too similar in temperament are always complicated, but the people who knew them both described it as fundamentally caring. He brought her groceries on Thursdays. He fixed things around the farmhouse when they broke. He drank her sweet tea on the porch in the evenings when he visited, which was often. He had also, in the year before his death, come to a decision about the farm. The land was worth, at current market assessment, approximately $1.4 million. Kyle Moon had learned this from a real estate attorney he had consulted, and he had brought the assessment to his grandmother and proposed that they sell, that they take the money and divide it fairly, and that Reba use her portion to move to a comfortable facility where she would have proper care rather than managing a farmhouse on her own at 82. He had framed this, according to the attorney who had been present at one of their discussions, as an act of concern. He had said he worried about her living alone. He had said the farm was more than she could manage. Reba Moon had said no. She had said it once and clearly and had not said it again, because to say it again would have been to acknowledge that the question was still open. In her understanding, the question was closed. Kyle Moon had not understood the question as closed. The insurance policy had been taken out 14 months before his death. The agent who had sold it, a man named Thomas Greer, who had been in the insurance business in Ashford County for 21 years, would testify that Reba Moon had come to his office accompanied by Kyle, had presented herself as a grandmother concerned about final expenses, and had initiated a conversation about policies. It had been Reba who had steered the conversation toward life insurance, on Kyle rather than a burial policy on herself. It had been Reba who had specified the coverage amount, $750,000, and who had asked specific questions about the payout timeline and the beneficiary designation. Kyle had been present throughout this conversation. Thomas Greer had noted that Kyle had seemed slightly confused by the direction the conversation was taking, but had not objected, and that Reba had handled the paperwork with an efficiency he had found notable in a woman of her age. The policy had been in force for 3 months when Kyle Moon died. Detective Carolyn Price had been the lead investigator on the case, assigned to it by the Ashford County Sheriff's Department the morning Kyle's body was found. She was a methodical woman of 51 who had worked property crimes and financial investigations for 15 of her 23 years on the force before transferring to major crimes, and this background had given her a particular eye for certain categories of motivation that other detectives sometimes underweighted. She had read the initial report on the drive to the farmhouse. She had noted Kyle's age. She had noted that he had been found in the kitchen, that there was a glass of sweet tea on the table beside the chair where he had been sitting, and that Reba Moon had reportedly been asleep in the back of the house and had not heard anything. She had stood in the kitchen of the Moon farmhouse and looked at the sweet tea and the chair and the table and the back hallway, and she had thought about the insurance policy that the initial background check had surfaced. Then she had walked outside and stood on the porch in the January cold and called Diana Reeves. She had said, "I think we need to talk." The toxicology report, available 3 weeks after Kyle's death, had confirmed what the preliminary examination suggested. Kyle Moon had ingested a lethal quantity of a heart medication, digoxin, prescribed to Reba Moon, for a cardiac condition she had been managing for 11 years. The medication was present in his system at a level several times the therapeutic range, a level consistent with deliberate administration of a large dose rather than accidental ingestion. The nature of the substance's distribution in the gastric content was consistent with it having been introduced in liquid form, meaning it had been dissolved or thoroughly crushed before being added to something Kyle had drunk. The sweet tea. Defense counsel, a veteran Ashford County attorney named Gerald Foote, who had been practicing criminal defense for 31 years and who had agreed to represent Reba with a private arrangement funded by the Moon family's remaining assets, had filed the self-defense narrative within a week of the arraignment. He had constructed it carefully and professionally. The narrative relied on a pattern of documented emotional volatility in Kyle's behavior over the years, 2 prior incidents in which neighbors or family members had expressed concern about heated arguments between Kyle and Reba, and on Reba's own account of the evening before his death, in which she claimed Kyle had threatened her over the farm question. Gerald Foote had presented this narrative in his preliminary filings with the conviction of a skilled advocate who was doing his best work with genuinely difficult material. He had not known about the recorded jail calls when he filed the narrative. When he learned about them, he had sat in his office for a long time before calling Reba to discuss the matter. The arraignment had taken place on a gray Thursday in March. The courtroom had been fuller than the standard arraignment attendance warranted because the story of the elderly widow who had said she would do it again had moved through Ashford County with the speed that certain stories move, arriving at kitchen tables and barbershops and the waiting areas of doctors' offices and acquiring, in each telling, a slightly different shape, but retaining at its center the image that had appeared on the local news. Reba Moon in her blue cardigan, looking directly into the camera, saying those 4 words with the quality of a woman who has made peace with something. When the clerk read the charge, Reba Moon sat with her hands folded in her lap and looked at a point slightly above the judge's bench. the specific attending posture she had been using in formal settings since childhood. She did not react visibly to the charge. Gerald Foote entered the not guilty plea, and the arraignment proceeded. In the corridor afterward, Reba had been surrounded briefly by cameras and had given the reporters what they had gathered for, the same composed statement, delivered in the same tone. She had repeated the core of the narrative, the fear, the threats, the protection of her home. She had said the word protection 3 times in 2 minutes. She was very good at the narrative. It was the narrative of a grandmother who had been backed into a corner and had done the only thing available to her, and she delivered it with the specific quiet forcefulness of a woman who has decided what she believes and is not interested in being argued out of it. Diana Reeves, watching the corridor footage that evening in her office, noted that Reba Moon never used Kyle's name. She said her grandson, she said him, she said his behavior. She did not say Kyle. Diana Reeves wrote this in her notes. It was not evidence. It was observation, the kind of observation that goes alongside evidence and helps you understand the shape of what you are looking at. The trial opened on the first Tuesday of May with a gallery divided in the way that cases involving sympathetic defendants are always divided between the people who had come prepared to see justice delivered and the people who had come prepared to see a frightened old woman vindicated. Both groups were present, and they occupied the gallery in a way that was visible, the victim's family in the front rows, the community members who had been following the story distributed throughout the remaining seats. Ashford County had known Reba Moon for 6 decades. She had been a fixture of the community in the way that people who stay in the same county all their lives become fixtures, present at church picnics and school board meetings and the various civic events that mark the rhythm of a small county's year. People had eaten food she brought to potlucks. People had bought eggs from the Moon Farm for 30 years. People had opinions about her as you form opinions about someone you have known at various distances for 60 years. And those opinions were generally favorable in the general way. The way a person who has not given you specific cause for concern is generally thought well of. The disclosure of the murder charge had divided those opinions sharply and in the specific way that certain disclosures divide communities. Between the people who updated their understanding of a person based on new information and the people who found the new information impossible to reconcile with their existing understanding and therefore doubted the new information rather than the existing understanding. Both positions were represented in the gallery and in the letters to the editor of the Ashford County Register, and in the conversations at the diner on Main Street, and in the waiting area of the county health department. Kyle Moon's sister, Amber, sat in the front row with her husband. She was 29, and she had driven from Charlotte the night before, and she was carrying something that was not entirely visible in the set of her jaw and the angle of her shoulders, the specific weight of grief that has been complicated by the person responsible for it being someone you are supposed to love. She had loved Reba. She had grown up eating Reba's cooking and spending summers on the farm and sitting on the porch in the evenings in the time before everything got complicated. She had not known what Reba was capable of, and the not knowing had its own particular weight. Reba, wheeled to the defense table, settled her knitting in her lap. She had asked the court through Gerald Foote whether she would be permitted to knit during proceedings as a medical accommodation for her arthritis, claiming that keeping her hands gently occupied reduced pain. The judge, the Honorable Marcus Tatum, had reviewed this request and denied it for general proceedings, but had made a limited allowance during the opening statements as a preliminary accommodation, noting that the matter might be revisited. Reba had accepted this with a nod and had begun knitting with the composed, rhythmic movements of someone who has been doing this particular thing for 60 years and finds in it a reliable form of calm. Several reporters photographed this immediately. The photographs circulated quickly. They circulated because the image was arresting in a specific way, an 82-year-old woman in a blue cardigan sitting in a murder trial, knitting with the calm rhythm of someone passing a quiet afternoon at home. The contrast between the image and its context was the thing that made the photographs compelling. It was the contrast Reba had been producing deliberately since her arrest, the contrast between the grandmotherly surface and the serious charge, and she had learned over the preceding weeks that the contrast worked in her favor with certain audiences. She had not yet learned that it would not be sufficient. Judge Marcus Tatum was 63 years old, a former state attorney who had been on the Superior Court bench for 17 years and who had, in that time, presided over cases of considerable complexity and of considerable media attention, and who had developed a capacity for maintaining the precise equilibrium that such cases required, the equilibrium between the court's obligation to manage the proceedings and its obligation to follow the evidence wherever it led. He had read the full case file the weekend before the trial opened. He had read it again the following morning. He was a thorough man, and he was a patient man, and he had formed, from that reading, certain clear impressions that he was prepared to act on at the appropriate time. Diana Reeves's opening statement was 40 minutes long, and it was the opening statement of a prosecutor who has built a case from the outside in, who began with the observable facts and moved toward the center, establishing what was beyond dispute before establishing what the evidence would show about what could not be disputed. She described Kyle Moon, the 34 years, the contracting work, the relationship with his grandmother, the farm. She described the toxicology. She described the insurance policy. She described the pharmacy purchase. She described the nature of the calls Reba Moon had made from the county jail in the weeks following her arrest, made on the jail's recorded system, as all calls from that facility were recorded, as all defendants at that facility were informed at intake. She said the state would play one of those calls for the court. She said the court would hear Reba Moon's voice on a recording made without coercion, describing what she had done and why. She said the court would hear the specific reason that had nothing to do with fear. She sat down. Gerald Foote's opening statement was 35 minutes, and it was technically accomplished and professionally delivered. He described Kyle Moon's volatility, the prior incidents, Reba's fear of losing control of her home. He spoke about the specific vulnerability of an elderly woman living alone with a grandson whose behavior had become threatening. He spoke with the conviction of an advocate doing his professional best. He did not mention the jail calls. Reba, during both opening statements, sat with a quality of composed attention that several gallery members found unsettling in ways they could not immediately specify. She was not nervous. She was not distressed. She was present, attentive, managing the room in the specific way of someone who has decided that managing the room is a thing they can do, that the room is a thing that can be managed. The first week of testimony established the physical and forensic foundation. The medical examiner testified about the cause of death, the digoxin toxicity, the specific pathway by which a dose of that magnitude would have affected a person with Kyle Moon's physiological profile. He described the time from ingestion to incapacitation and the time from incapacitation to death. And he was careful with his language, as good medical examiners are, saying consistent with rather than proves. But the picture he assembled was clear, and the jury received it clearly. He said that digoxin in therapeutic doses regulates cardiac function. He said that in doses several times the therapeutic range, it disrupts cardiac function in ways that progress to fatal outcome within hours. He said the dose found in Kyle Moon's system was not consistent with accidental exposure or with a person self-administering medication inappropriately. He said the dose was consistent with deliberate administration of a large quantity, and that the nature of the substance's distribution in the gastric fluid was consistent with the substance having been dissolved or finely crushed before ingestion rather than swallowed in pill form. He said this with the care of a scientist who understands that careful language is more powerful in a courtroom than dramatic language, because careful language does not invite challenge in the same way. Gerald Foote cross-examined on the possibility of self-administration, on the range of individual variation in digoxin metabolism, on the theoretical pathways by which exposure could occur accidentally. The medical examiner acknowledged the theoretical existence of each pathway and explained for each why the specific circumstances of this case made the theoretical pathway implausible. He was an experienced witness, and he was unshakable on the things that mattered, and appropriately flexible on the things that did not. Reba, during the medical examiner's testimony, maintained her composure with the precision of someone who has rehearsed composure. When the medical examiner described the progression of digoxin toxicity, the stages of cardiac disruption, the experience of a person whose heart function was being systematically compromised. Something moved in her expression for a fraction of a second, something that might have been discomfort or might have been calculation, and was gone before it could be categorized. Thomas Greer, the insurance agent, testified on the third day. He was a mild-mannered man who had clearly not enjoyed the months since the case had become public knowledge, and who gave his testimony with the relieved efficiency of someone who wants to tell the truth and be done with it. He described the insurance meeting in detail, Reba's specific questions about the payout timeline, the beneficiary designation, the process by which the policy would become effective. He said that in 21 years of selling insurance, Reba Moon had been the most focused and specific client he had dealt with regarding the mechanics of a life insurance payout. He described how she had asked, within the first 10 minutes of the meeting, about the contestability period, the 2-year window during which an insurance company could investigate a death claim before paying. He said she had asked specifically what would happen if a death occurred after the contestability period had passed. He said he had explained that a death after the contestability period would be paid out on the standard timeline without investigation, assuming the policy was in good standing. He said Reba Moon had nodded and had asked him to confirm this in writing. The policy had been purchased 13 months before Kyle's death. The contestability period was 2 months past when Kyle died. This sequence of facts sat in the courtroom for a moment after Greer finished stating it. Several jurors looked at the defense table. Reba was knitting with her eyes on the needles. Gerald Foote cross-examined on the ordinariness of insurance purchases, on the ways in which financial planning by elderly people routinely involved life insurance on younger family members. Thomas Greer acknowledged that such purchases were not unusual. He held firm on his specific characterization of Reba's focus and specificity, and on the contestability period question, which he said he had never been asked before in 21 years of selling insurance, and which he had found memorable for that reason. Foote sat down, having made a reasonable point that the jury would weigh against the specific facts of this particular transaction. Reba, during Greer's testimony, had let her knitting needles rest. She sat with her hands in her lap, watching the witness with the composed, assessing expression she brought to everything. When Greer described her specific questions about the contestability period, something moved briefly in her expression, a small tightening at the corners of her eyes that was gone in a second, replaced by the same composed attention. Juror number 3, Louise, watched this and wrote in her notepad. Juror number 8, Charles, watched this and did not write anything. They were both thinking about the same sequence of facts, the policy, the contestability period, the timing of Kyle's death, and they were both arriving at the same assessment from different directions, the assessment of two people who have been paying close attention and who can see the shape of a thing when enough of it is visible. The pharmacy surveillance footage and the pill crusher receipt came in the second week. The CCTV stills, enhanced and printed for the jury, showed a woman in a pale cardigan purchasing a small appliance from the pharmacy's kitchen equipment section. The woman's face was visible in 3 of the stills, and a forensic image analyst had provided testimony establishing that the face in the stills was consistent with Reba Moon's documented appearance. The receipt, recovered from the pharmacy's transaction records, showed the purchase date, 11 days before Kyle Moon's death. Reba had not mentioned buying a pill crusher to anyone. She had not mentioned it in her initial interviews with Detective Price. She had not mentioned it in any of her public statements. It was a small, specific omission in an account that otherwise had the texture of a prepared story, and the jury noted it. Amber Moon, in the front row, looked at the stills on the courtroom display for a long time. She looked at the woman in the pale cardigan, and she thought about all the Thursday afternoons her brother had driven to the farmhouse with groceries, and she thought about the sweet tea, and she looked at the pill crusher receipt, and she set her jaw and did not look away. The neighbor, a woman named Carol Betts, who lived half a mile down the road and had known Reba Moon for 30 years, testified on the 8th day of the trial. She described the evening before Kyle's death, when she had passed the Moon farmhouse around 7 and had seen Kyle's truck in the drive and the kitchen light on, and had thought nothing of it, because Kyle's truck was often in the drive in the evenings and the kitchen light was often on. She said she had not heard raised voices. She had not heard anything unusual. She said the farm had been quiet. This was the testimony that the self-defense narrative most needed to be wrong, and it was not wrong. It was a neighbor telling the truth about what she had observed, and what she had observed was an ordinary evening, and no sign of the confrontation that the defense claimed had precipitated Reba's action. Gerald Foote cross-examined on the distance between the road and the house, on the neighbor's limited field of view, on the possibility that an interior confrontation would not have been audible from the road. Carol Betts agreed that she could not have heard everything from where she was. She maintained that she had heard nothing unusual from the distance she was at, and that in 30 years of living near the Moon farmhouse, she had sometimes heard things when things were happening and had heard nothing that evening. Reba, during Carol Betts's testimony, shook her head once, and then did not move. The announcement of the jail call came on the morning of the 9th day. Diana Reeves told the court that the prosecution would be presenting an audio recording made on the Ashford County Jail's standard telephone system on a date she specified, a date 11 days after Reba Moon's arrest and 3 days after the life insurance payout had cleared the estate's account. She said the recording was a call between Reba Moon and her sister, a woman named Eunice who lived in Raleigh, and that the call had been authenticated by both the jail's recording system administrator and by a forensic audio analyst who had performed voice identification analysis on the recording. Reba's knitting had slowed during the announcement. Not stopped, but slowed, the needles moving with slightly less of the automatic 60-year rhythm and slightly more of the deliberate, managed rhythm of someone who is consciously maintaining an activity. Her jaw had tightened once, visibly, and had relaxed. Gerald Foote, beside her, had written something on his notepad and had not looked at her. The forensic audio analyst, a specialist from the North Carolina State Bureau of Investigation named Dr. Patricia Ossie, testified on the morning of the 10th day. She was a composed and methodical witness who explained the jail recording system with technical precision and described the authentication process she had applied to the specific recording. She described the voice identification methodology, the comparison of the recorded voice against reference samples from Reba Moon's arraignment hearing, and the confidence rating produced by the analysis, which she described as high. Gerald Foote cross-examined on the technical limitations of voice identification analysis, on the variables that can affect acoustic profiles, on the gap between statistical confidence ratings and absolute certainty. Dr. Ossie engaged each point with the equanimity of an expert who has been cross-examined many times on methodology and who trusts the foundation of her work. She held her conclusions throughout. When Foote sat down, Diana Reeves stood. She looked at the court technician. She said, "Your Honor, the state moves to admit Exhibit 61. Judge Tatum said, "Admitted. Proceed." The recording was 2 minutes and 47 seconds long. The courtroom's audio system was not sophisticated, but it was sufficient. The recording came through the speakers with the specific flat quality of telephone audio, slightly compressed, slightly distant, but entirely clear. Eunice's voice came first, asking how Reba was holding up. Reba's voice said she was managing fine. She said the food was not good, but she had endured worse. Eunice asked whether the lawyer thought things looked all right. Reba's voice said Gerald was doing what he could. She said it did not matter much at this point because the main thing was handled. Eunice asked what she meant. Reba's voice said calmly, in the same tone she might use to discuss the weather or the price of feed. Once that policy cleared, I wouldn't have to worry about him losing the farm. The courtroom went completely still. The stillness was total and physical. The stillness of a room in which every person has simultaneously stopped doing whatever they were doing, stopped shifting in their seats, stopped breathing. In the ordinary way, stopped anything that was not attending to what was coming through the speakers. The reporters had their notebooks and their recording devices, and they were not moving. The jury sat without movement. Several of the gallery members had their hands to their faces in the specific anticipatory posture of people who are bracing for something they have already understood is coming. Eunice's voice asked, after a pause, "You really put it in his tea?" Reba's voice said, "Crushed fine. He never tasted it." The sound that moved through the gallery was soft and collective, the sound of many people receiving the same information simultaneously in a room with no distance to absorb it. It was not a gasp so much as an exhalation, the release of breath that had been held in the 2 seconds between Eunice's question and Reba's answer. There was a brief silence on the recording. Then Eunice said something that the audio did not fully capture, a low murmur of response. And then the call continued with ordinary matters, Eunice asking about a relative's health, Reba asking about the weather in Raleigh, the conversation becoming mundane in the specific way that conversations become mundane after they have contained something that should not be mundane at all, as though the admission had been a small item in a longer list, rather than the central fact of a murder trial. The recording ended. Reba Moon's knitting needles were on the floor. She had not dropped them dramatically. They had slid from her hands with the slow inevitability of something no longer being held, and they lay at her feet on the courtroom floor, and she was looking at a point somewhere past the prosecution table, her lips slightly parted, her expression carrying the specific quality of a person who has just heard something they knew was coming and had believed they were prepared for and have found they were not prepared for in the way they thought. The composure was not gone. It could not go entirely because the composure was structural rather than performed, built into her over 82 years of managing difficult things. But it had shifted. It had moved from the active composure of someone managing the room to the passive composure of someone who has simply stopped moving, who is sitting with something that does not require management because management is no longer relevant. She said very quietly to the space in front of her, "That's not." She did not finish the sentence. Gerald Foote sat with his notepad face down on the table. He had spent the preceding 2 weeks attempting to prepare an argument that could address the recording if the judge admitted it, an argument about context and selective recording and the emotional state of a woman in a jail cell speaking to her sister, and he had found, in the preparation of that argument, that it had no weight. The recording said what it said. Reba Moon's voice said what it said. The voice identification was confirmed. The timestamp was confirmed. The GPS coordinates from the payout confirmation document aligned with the date she mentioned. There was no argument. There was only what came next. In the gallery, Amber Moon had both hands over her mouth. Her husband had his arm around her, and she was leaning slightly toward him, but she was not looking away. She was looking at the back of Reba's head, at the white hair and the tortoiseshell clip, at the blue cardigan, and her expression was the expression of a person who has been carrying a question for months and has just received the answer and has found that the answer, despite having suspected it, is harder to bear than the question was. She was thinking about the tea. She had drunk tea from that pitcher. On summer evenings and on fall afternoons and on the Thursday visits she had made with Kyle, the two of them sitting on the porch with glasses of sweet tea that Reba made from a recipe she had been making since before either of them was born. She was thinking about that, and about crushed fine, and about he never tasted it, and about the specific domestic intimacy of making tea for someone who trusts you to make it. Diana Reeves let the silence work for its full measure before she stood. She said for the record that the prosecution's case rested. She sat down. Judge Tatum looked at the defense table. He said, "Mr. Foote." Gerald Foote stood and said that the defense rested as well. His voice was entirely professional. His face was not showing anything that was not professional. He sat down. The jury deliberated for 5 hours. The verdict was guilty of murder in the first degree. When the verdict was read, Reba Moon sat in her wheelchair and looked at the floor. The composure she had maintained throughout the trial was not gone exactly, but it had changed in quality. What remained was not the performing composure of a woman managing her image in a room full of cameras, but something simpler and less useful. The composure of a person who has run out of room to maneuver and who is now sitting with what is left. She did not cry. She did not speak. She sat with her hands in her lap, the knitting needles still on the floor where they had fallen, and she was quiet. Judge Tatum called the sentencing hearing for the following morning and adjourned for the day. The sentencing hearing opened on a Wednesday morning with the victim impact statements. Amber Moon read hers from a prepared text that she had written and rewritten over the preceding weeks, each draft an attempt to find language sufficient for what she needed to say. She stood at the podium and read in a voice that was steady for most of it and less steady near the end. She said that Kyle had trusted Reba to make his tea. She said that he had driven to the farmhouse every Thursday for years, had sat on the porch in the evenings, had brought groceries, had fixed things when they broke, had been, despite their complications, her grandmother's most consistent presence and her most reliable help. She said that the trust required to drink tea that someone has made for you is the most fundamental kind of trust, the trust that exists between people who have known each other since childhood, the trust that should not have to be thought about. She said, he trusted her with his life. She took it. She sat down. The other family members who spoke did so briefly, because there is a limit to how many ways you can say the same thing, and the thing they were saying was true, and had been true, throughout the trial, and would remain true, and saying it once clearly was sufficient. Gerald Foote offered mitigating factors with the professional thoroughness of a man who is doing everything his role requires, while knowing that the recording has placed the outcome beyond the reach of mitigation. He spoke about Reba's age, her health, her clean record, the genuine complexity of the family dynamic. He spoke with conviction, because conviction was his professional obligation regardless of probability. He sat down. Diana Reeves stood for the prosecution's sentencing recommendation and said what the evidence supported, which was the maximum sentence available. She said it without drama because the drama was not necessary. The recording was in the record. The sentence would be what it would be. Judge Tatum looked at Reba Moon for a long moment before he spoke. He had the quality of a man who has spent 17 years measuring his words in rooms where words have consequences, and who has arrived, after those 17 years, at a precise understanding of which words are needed, in which moments. He said, "Ms. Moon, I want to address you directly before I impose sentence, because this court has an obligation to speak plainly about what has occurred in these proceedings." Reba Moon looked up at him. Her expression was quiet in the specific way of a face that has exhausted its available expressions and is now present without managing. He said, "You came to this court with a narrative. You have maintained that narrative with considerable skill and commitment throughout these proceedings. The narrative portrayed a frightened woman who acted in desperation to protect herself from a threatening grandson. You have described yourself as acting out of fear. You have said publicly and repeatedly that you would do it again. He paused. The recording this court heard yesterday speaks to the meaning of that statement, he said. You said you would do it again. This court now understands what again refers to. It does not refer to an act of protection. It refers to an act of calculation. The recording establishes that your primary concern after your grandson's death was not the grief of having lost him, not the trauma of having acted in fear, not any of the things that a person who killed another person out of desperation would experience. Your primary concern was that the insurance policy had cleared. The courtroom was completely still. You told your sister on a recorded call made from a county jail that once that policy cleared, you would not have to worry about him losing the farm. You confirmed that you had crushed medication into his tea. You described it in the tone of a person describing a practical problem they have solved. The medication was prescribed to you for a legitimate cardiac condition. The tea was something he trusted you to make. You used both of these things as instruments. He looked at her steadily. The prosecution has established the following sequence of facts, he said. You took out a life insurance policy on your grandson, naming yourself as sole beneficiary, 14 months before his death. You asked the insurance agent in that initial meeting specifically about the contestability period, the window during which claims can be investigated before payment. You purchased a pill crusher from a local pharmacy 11 days before Kyle Moon died. You made sweet tea for your grandson on the evening of his last visit to the farm. Kyle Moon died that evening from digoxin toxicity at a dose several times the lethal range. The insurance policy paid out 3 days before you made the jail call in which you confirmed what you had done. He paused to let the sequence sit. Each piece of this sequence is documented. The insurance documents are in evidence. The pharmacy receipt is in evidence. The toxicology is in evidence. The voice recording is in evidence. And your own voice in a conversation you made because you believed its contents were private confirms the sequence and confirms the motive. The motive was the farm that Kyle Moon wanted to sell, the farm you had lived on for 60 years and intended to remain on and intended to retain the value of. You valued the farm over your grandson's life, and you acted on that valuation with thoroughness and patience. He looked at her for a long moment. You are 82 years old. This court has taken your age seriously throughout these proceedings, as it takes all relevant facts seriously. Age is a fact, and it has procedural significance, and this court has considered it in its determination. What age is not, and what this court must be clear about, is a license. Age does not excuse premeditation. Age does not excuse the deliberate planning that the evidence establishes over the 14 months preceding your grandson's death. The insurance policy was taken out 14 months before he died. The pill crusher was purchased 11 days before he died. The tea was made for him on the last evening of his life by the person he trusted most to make it. He paused again, allowing the weight of the sequence to work without embellishment. You told this court you acted in fear. Your own voice, in a conversation you made no effort to guard because you believed the content would never leave that phone call, tells a different story. Your voice speaks of profit. Your voice speaks of planning. Your voice speaks of a farm you did not intend to lose, and a policy you had arranged to ensure that you would not lose it, and a man you had decided was a problem to be solved rather than a grandson to be loved. The gallery was motionless. This court has observed you throughout these proceedings presenting an image of grandmotherly fragility. The knitting, the soft voice, the blue cardigan, these are not crimes. Presenting a certain image to a jury is not a crime. But this court notes that the image was constructed and maintained with as much deliberateness as the crime itself, and that the constructed image and the recorded voice are in complete and irreconcilable contradiction, and that this court is required to act on what the evidence shows rather than on what the image suggests. He looked at her for a long moment. "Betrayal within a family is among the gravest crimes this court encounters," he said. "Not because family. Betrayal is legally distinct from other forms of murder, but because the harm it does extends beyond the victim. It reaches into the people who shared a table with the victim, who trusted the same person the victim trusted, who now must live with the knowledge that the place they believed was safe contained something that was not safe at all." Amber Moon drove to the farmhouse on Thursdays sometimes with her brother. She sat on the same porch. She drank tea from the same pitcher. She will live the rest of her life knowing that. Amber Moon, in the front row, was looking at her hands. "You calculated the value of a life," Judge Tatum said. "You weighed your grandson against the farm and against the insurance policy, and you arrived at a number, and you acted on the number. Age does not excuse greed. Frailty of appearance does not excuse deliberateness of intention. The grandmotherly image you have presented to this court and to the cameras since your arrest does not change what the evidence establishes, which is that you are a person who planned the death of a person who trusted you and who executed that plan with thoroughness and patience and who felt, when it was done, not horror, but relief." He straightened his papers. "The sentence is 20 years in North Carolina State Prison. Parole eligibility will be restricted in accordance with the first-degree murder conviction. This court acknowledges the defendant's age and physical condition and notes that the Department of Corrections will provide appropriate medical accommodation within the facility. These accommodations do not alter the nature or duration of the sentence, which reflects the gravity of the offense and the deliberateness of its commission." He looked at Reba Moon one final time. "You will be remembered," he said, "not for the image you cultivated, but for what the evidence revealed. Mercy has its place in this court, but mercy cannot replace accountability. This court is adjourned." The gavel came down. Reba Moon sat in her wheelchair and did not move for a long moment. The composure had not broken into weeping, which was perhaps the final surprise the trial contained, because the composure was, apparently, genuine and deep, and not a performance at all, but the actual structure of the person, and the person did not weep, not publicly, not with cameras present. She sat with her hands in her lap, and her eyes on the floor, and her shoulders sagged in the specific way of a person who has been holding something up for a very long time, and has now set it down. She was quiet. The deputy who came to take her was professional and appropriate, and helped her with the wheelchair, and they moved toward the exit with the unhurried practicality of institutional process, which continues regardless of the circumstances of those it processes. The cameras captured her blank expression as she passed the gallery. Several of the cameras were still running when she reached the door and was wheeled through it. Amber Moon sat in the front row and did not watch her grandmother leave. She was looking at her husband's hands, which were holding hers, and she was thinking about Kyle and about the farmhouse and about the porch and the sweet tea and the Thursday evenings. And she was thinking that there was no way to make the thinking stop, that you could not unknow what you now knew, and that the knowing was going to be a part of every subsequent Thursday for the rest of her life. Her husband said something to her quietly, and she nodded once, and they sat together while the room around them cleared. The Moon farmhouse sat on its 43 acres in Ashford County and continued to sit there in the weeks following the sentencing while the estate's legal situation worked itself through the proper channels. The rocking chair on the porch, where Reba had sat on evenings for 40 years and where Kyle had sat beside her on the Thursdays he came with groceries, remained on the porch. It was not a symbol. It was a piece of furniture on a porch. It was a chair that had held a woman who had planned a murder and held a young man who had trusted the woman who planned it. And it was empty now in the way that things are empty when the people who use them are gone. Without commentary, without moral weight of its own, simply present, and without occupant on a porch that the county spring had covered in the ordinary greening of trees and the ordinary warmth of longer days. Detective Carolyn Price had submitted her final case report and had driven home and had sat on her own porch for a while in the May evening. She was thinking about the jail call, not its content, which she had heard many times, but the fact of it, the casual ease with which Reba Moon had described what she had done to a relative on a recorded line, the specific confidence of a person who has done something and feels no need to be careful about it because they believe they are unreachable. They are never unreachable, she thought. They always believe they are, and they are never right. And it was this that she thought about, not as a satisfying thought, but as a practical observation about how investigations work and why thoroughness matters and why the answer is almost always already in the evidence if you look at enough of it and ask enough of the right questions. She sat on her porch until the evening light changed, and then she went inside and made dinner and did not think about the Moon case for the rest of the night because that was a skill she had spent 23 years developing. The ability to set the work down at the end of the day and let it wait, because the work was always there in the morning and a person had to sleep. In the Ashford County Evidence Archive, Exhibit 61 sat in its sealed bag, the recording preserved on the secure storage system as required by the case retention protocols. 2 minutes and 47 seconds of audio in which an 82-year-old woman described in the calm, practical voice she used for all practical matters how she had crushed medication into sweet tea and watched a young man drink it and had felt, when the insurance policy cleared, not grief, but relief. The recording did not require any context to be what it was. It was what it was completely and without ambiguity, a voice saying a true thing in the specific tone of someone who believes truth has no consequences for them. The voice had been wrong about the consequences. The recording had waited on a jail system server for the moment when the consequences arrived, and had been ready when they did, indifferent to everything except the fact that it had been made and had been preserved, and would play, when it was played, exactly as it had been recorded. Reba Moon had made the call on a jail phone because she had believed the call was private. She had been informed, at intake, that calls were recorded. She had forgotten or had not. Credited or had calculated in the specific way she calculated everything that the recording would never matter because she would not be convicted, because she was 82 and fragile and sympathetic. And this was a grandmotherly narrative that juries found difficult to convict against. She had done the calculation, and the calculation had been wrong, and the recording had played in a courtroom, and her needles had fallen to the floor, and the grandmotherly narrative had ended. What remained was the silence that follows when a story is over, the specific silence of a courtroom after the gavel has come down for the last time on a case, when the gallery empties and the reporters gather their things and the family makes its way out and the evidence is logged and archived and the room returns to itself, ready for the next matter on the docket, indifferent to what it has held, clean and quiet and waiting. The community of Ashford County did not arrive at a unified response to Reba Moon's conviction, because communities rarely do when the person convicted is someone they have known for a long time and in multiple dimensions. The letter to the editor column of the Ashford County Register ran, in the weeks following the sentencing, both letters from people who expressed relief that the evidence had been what it was, and letters from people who expressed sorrow that an elderly woman was going to spend however many years remained to her in a state facility. And the letters did not fully persuade each other and were not intended to. Several people who had been vocal in their support of Reba's self-defense narrative had nothing to say after the recording was played in court. This silence was itself noted, not cruelly, but as a factual observation by the people who had been saying from the beginning that the evidence pointed in the direction it pointed, and who had been dismissed as uncharitable. They did not celebrate being right. Being right about this was not a thing you celebrated. It was a thing you noted and moved forward from. The Moon Farm was placed under a state administration pending the resolution of the legal questions about the insurance policy, which the insurance company was contesting on the grounds of fraudulent procurement. This contest would work through its own process over the following year and would ultimately produce a settlement that made the payout unavailable to the estate for purposes connected to the original claim. The farm itself remained standing on its 43 acres, and the county continued to grow around it, and the land's value continued to accrue, indifferent to the human events that had occurred on it. Amber Moon visited the farm once in the fall following the trial, on a day in October when the light was flat and the fields were the color of dried grass. She had not been back since January. She had gone in the morning, alone, and had walked around the exterior of the house and had stood on the porch for a few minutes. She had looked at the rocking chair where Reba had sat. She had looked at the screen door and the kitchen window and the yard. She had thought about Kyle and about the Thursday evenings and about the tea. Then she had gone back to her car and had driven back to Charlotte and had called her husband from the road to tell him she was on her way. And he had asked how she was, and she had said she was okay, and this had been approximately true, which was as much as she could ask of it. In the North Carolina State Correctional System, an 82-year-old woman was assessed and housed in the facility's medical unit, where her cardiac condition and mobility limitations could be properly managed. She received her medication, prescribed by the facility's physician, in its proper therapeutic dose. Supervised, administered correctly, as medication should be administered. She was not the oldest resident of the facility, but she was among the oldest, and the staff noted her composure, which was total and unvarying, which never softened into the kind of emotional expression that most residents eventually display, and which was, in its unbroken consistency, the most striking thing about her. She did not speak about the case to anyone at the facility. She did not speak about Kyle. She did not speak about the farm. She sat with the composure she had brought to the courtroom, and the composure she had brought to 60 years of managing things on her own. And the composure held because it was structural, because it was the architecture of the person, and the architecture did not require acknowledgement or approval or any external validation to stand. Detective Carolyn Price submitted her final case report and closed the file. She drove home and sat on her own porch for a while in the May evening, thinking about the jail call, not its content, but the fact of it, the casual ease with which Reba Moon had described what she had done, because she believed she was unreachable. They always believe they are unreachable, she thought. The evidence is always already there if you look at enough of it and ask the right questions and follow the line between what happened and what was done to make it happen. She went inside when the evening grew cold and made dinner, and did not think about the Moon case for the rest of the night, because that was a skill she had spent 23 years developing, and it served her well. The work was always there in the morning, and a person had to sleep. In the Ashford County Evidence Archive, Exhibit 61 sat in its sealed bag, the recording preserved as required by the case retention protocols. 2 minutes and 47 seconds of audio in which a voice said, "crushed fine," and he never tasted it. In the same practical tone used for all practical matters, a voice that had believed truth had no consequences for it, that had been informed otherwise, and that would remain in the archive for as long as the law required, indifferent to everything except the fact that it had been made and had been preserved, and had played, when it was played, exactly as it had been recorded. The rocking chair on the farmhouse porch sat through the fall and into the winter, holding the accumulated weight of seasons and the specific absence of the people who had occupied it. It was not a symbol. It was a chair. It was a chair on a porch of a farmhouse on 43 acres in Ashford County, North Carolina, where a woman had lived for 60 years and where a young man had drunk sweet tea on Thursday evenings because he trusted the woman who made it, and where nothing remained now except the ordinary continuation of the land and the light and the indifferent passage of time through the particular corner of the world that had been the Moon Farm. The case generated, in the months following the sentencing, a policy discussion in North Carolina and in several other states about the financial exploitation of vulnerable populations by family members, and, less obviously, the financial exploitation of family members by elderly relatives, a category of harm that existing elder exploitation statutes had not been designed to address, and that the Moon case made visible. Legislators and advocates used the case as a reference point in hearings about updating elder exploitation statutes to capture a broader range of financially motivated family crimes. The Moon case was cited in 3 separate legislative hearings in the year following the sentencing. In each hearing, someone read the words from the recording into the public record, and the words did not become less clear with repetition. Diana Reeves followed these hearings from her office and responded to the occasional inquiry from legislative staff about the specific evidence in the case. She answered the inquiries professionally and provided what information she could under appropriate disclosure rules. When a staff member for a state senator asked her during one of these calls whether she had expected the case to have this kind of broader impact, she said she had not expected it and had not planned for it, and that the case had been what the case was, which was a murder investigation in Ashford County, and that the broader impact was what the broader impact was, which was something other people were working out, and that the work she had done was the work in front of her and not the work of anticipating what would follow from it. She said this and meant it. She was a prosecutor, and prosecutors try cases. What the cases become afterward is a different matter and belongs to different people. She had tried the case had ended. There was more work to do.